Well, there's no country in the world which has an intelligence service which functions where you're ever going to have a justice system where the spies all come out, identify themselves, give their evidence in public, all the intelligence material is revealed to the other side, reported in the press, and all the rest of it. You might as well give up.
Of course, that's an extreme characterisation.
You
there,
give up an
it?
intelligence service. Yeah, that's right. So but all I'm saying is there's got to be constraints. There are a whole, most other walks of life, you and I would agree, no, you've got to give your evidence and it's all got to be discled and all the rest of it. So what we've tried to do is get the balance right between seeing justice done on the one hand and not compromising genuine national security interests on the other. And the access to foreign intelligence, which is given to us on a confidential basis, is a relevant factor to that. The Americans and others, but most importantly the Americans, don't share the intelligence material with us on the basis that it's all going to be disclosed in litigation in the British courts. So what we're trying to get is the balance right. We've taken a long time producing this green paper because I share all your sensitivities about justice and the accountability of intelligence services and so on. What we're proposing is better than we have now because it will allow the cases to be tried. And when you get into those areas where there are genuine, compelling national interest reasons why you can't handle it as ordinary evidence, either witnesses or material, you go into closed session. The difference from now is the judge with special advocates. No. And the judge, for the first time, will be able to reach a conclusion. Unfortunately, only he will have heard all the evidence.
This is the
client will only get the gist of it.
But
at the moment, you can't try them. They just collapse at the moment.
But let me just put it to you.
In America, they try them. We're just leaving the intelligence stuff out.
Civil claimants can't be told by the special advocate what's happened in the court.
They can be given the gist of it.
The gist, okay.
Yes, but we are consulting. If you can strengthen that. Any decent ideas, we're welcome. I want to make the gisting as strong as we can, but of course you can't. But
if they can't instruct their special advocate, how is this a fair trial?
If he's a villain, the thing he's dying to know is how did they catch me? I mean, let's prejudge them, but some of them...
Well, absolutely, let's not.
But don't treat them all as also innocent victims either. Some of these people who are bringing actions for damages or whatever, in the Bin Mohammed case, we've got a sort of Norwich Pharmacal application and all that. Some of these will actually be very dangerous terrorists. Now, the one thing he's dying to know, and his lawyers are dying to know,
is that your presupposition?
Is to know how did they get us? Who have we got who's shopping us? What techniques were they using that got us? And if lawyers won't face up to the problem, that he can't be allowed to know that, there's no solution. What I think, put forward in this green paper is a solution which at least will enable the judge to hear everything, and at least to enable the gist, sufficient one hopes to allow him to defend himself knowing the type of case he's facing to the plaintiff, if he's bringing a claim, defendant, well, the criminal case is not going to apply, but it's civil actions we're talking about, so that it can be done properly. At the moment what happens is the minister puts in a public interest immunity certificate claiming national security, and it's never heard. Neither side can use it, no evidence, case collapses, you have to settle it. In the Guantanamo Bay detainees case, everybody's left believing their conspiracy theories. Everybody's on the side of the complainants, believes the British were complicit in torture. Everybody on the other side thinks we're paying out millions of pounds to terrorists because the lawyers are being so silly. As a citizen, I would like the judge to have been able to reach a position where he could declare a decision in that case. And what I'm putting forward is a proposal that would make that far more likely. And we're consulting on it, because I'm worried about how does the special advocate take instructions. He's got to know roughly what he's going to face. How does the special advocate give the gist of the case to the defendant? Is the special advocate in a position really to challenge what's going on and so on? All those are important questions, but they're ones to which we have to find an answer without compromising national security.